The morning I moved the last of the lumber off my truck, I wasn't thinking about Karen Whitfield. I was thinking about the shelf I was going to build in the garage, whether I'd measured the brackets right, and whether I had enough coffee left to get through the afternoon. That was it. That was the full scope of my concerns on that Saturday in October. I had the tailgate down, a 2x6 across my shoulder, and 1 foot on the driveway apron when I heard heels on asphalt. Fast, deliberate, the kind of walk that's trying to arrive before it's been invited. She was wearing a white polo shirt with Maple Crest HOA embroidered on the chest in navy blue thread. She had a laminated badge on a lanyard, her own photo, her own name, board president printed underneath like a title she'd awarded herself. She was carrying a clipboard with the grip of someone who believed the clipboard gave her authority. She stopped, 6 feet from me, looked at my truck, looked at the lumber on my shoulder, and did not say hello. You need to move that vehicle off HOA access property. Immediately. Not a question, not an introduction, an announcement delivered to someone she'd already decided was a subordinate. I set the 2x6 down on the tailgate. I looked at my driveway. I looked at her. I'm sorry, where are you reading that from? She tapped the clipboard. The access strip between your property line and the curb is recorded as HOA common area. Your truck is blocking community ingress. You have 5 minutes to move it. I want to be clear about what she was claiming. She was standing on my driveway apron, the strip of concrete between my garage and the public street, and telling me that I was trespassing on my own property. Not her property. Not the street. The apron I'd parked on every day since I moved in. The one attached to my house. The one on the deed I'd signed 4 months earlier. I asked, as calmly as I could manage, if I could see the document she was referencing. She pulled the clipboard back against her chest. I don't have to show you anything. I'm the board president. You have 5 minutes. 5 minutes to move off my own driveway. Off HOA common property. Yes. I looked at her for a moment. She didn't blink. There was something almost admirable about the confidence, the absolute, unexamined certainty that the clipboard and the polo shirt and the laminated badge meant that reality bent in her direction. Go ahead and make that call, I said. 2 words. I put my hands in my pockets and leaned against the tailgate. She dialed. I could hear the dispatcher's voice faintly through the speaker, that familiar cadence, the same one I'd listened to through radios and phones and open precinct doors for nearly 3 decades. Karen spoke in a measured, reasonable tone. There was a resident blocking HOA property. He was refusing to comply. She'd asked him to move twice. She needed an officer sent out. While we waited, she reached into her clipboard folder and produced a pre-printed violation notice, already filled out. My address in the property field, a description of the infraction, a dollar amount at the bottom, $350, first offense. She walked over to my truck and placed it under the windshield wiper with the practiced efficiency of someone who had done this many, many times. Then she turned back to me and smiled, not warmly. You're new here. I understand that. Maple Crest is a well-managed community. We take our standards seriously. People who can't follow the rules tend not to last long here. She said it pleasantly, the way you might tell someone the pool closes at 9. Friendly information. Not a threat at all. I looked at the violation notice under my wiper. $350. Signed in her handwriting. Dated today. Placed on a truck parked on a driveway that had been mine since the ink dried on a county deed. She'd placed that violation notice on my truck like she was doing me a favor. She had no idea she'd just handed me the first piece of paper in a case that would end her tenure as board president, drain the HOA's finances, and permanently change her relationship with the words, "I'm calling the police." I didn't say any of that. I picked the notice out from under the wiper, folded it carefully, and put it in my shirt pocket. The squad car pulled up 2 minutes later. I recognized the officer before he was out of the door. Of course I did. I'd promoted him myself. I want to tell you something about why I bought that house specifically. After the divorce was finalized, I spent 3 months looking at listings. Not because I couldn't afford to decide, because I was being careful. I'd spent the better part of my career in environments where carelessness cost people everything, and I wasn't about to let that habit slip in my personal life. I looked at 31 properties. I took notes on all of them. And when I found the house on Halston Court in Maple Crest, what sold me genuinely, embarrassingly, was one word in the listing description. Calm. Quiet, well-maintained suburban community. Calm atmosphere. Strong property values. I signed the purchase agreement 2 weeks later. I moved in on a Thursday. By the following Monday, I understood that calm had been doing a lot of heavy lifting in that listing. The first neighbor to fill me in was Fletcher Odom, who lived 4 houses down and ran a small landscaping crew out of his garage. He came over the second weekend to introduce himself, looked at the lumber I was unloading, the same lumber from the Saturday Karen appeared, and said, without any particular drama, "You met her yet?" I said I had. He nodded like I'd confirmed a medical diagnosis. "Then you know." I didn't. Not fully. Not yet. So I listened. Karen Whitfield had been HOA board president for 9 years. 9 consecutive years in a community whose own bylaws, Section 4.3, which I would not read until 3 weeks later, but which Fletcher had memorized out of sheer survival instinct, capped board members at 2 consecutive 2-year terms. 4 years maximum. She had simply stopped holding elections after year 4. The last residents who had attempted to run against her were a couple named the Hendersons, mid-40s, 2 kids, had lived in Maplecrest for 6 years. Karen's board assessed them 11 separate fines over the following 4 months. Cracks in the driveway, improper mulch species, a basketball hoop 2 inches outside the approved setback, a recycling bin visible from the street on a non-collection day. The Hendersons paid 4 of the fines, contested 3, ignored 4. The contested ones turned into a lien threat. They sold the house the following spring and moved to a county without an HOA. Fletcher said they looked, in his words, 10 years younger at the closing. I filed that information away and kept listening. The pattern Karen had built over 9 years was not subtle once you knew to look for it. Fines for grass exceeding 4 inches during a drought. Fines for the wrong variety of ornamental shrub, not prohibited in the bylaws, simply declared aesthetically inconsistent by Karen in a board memo that no one had voted on. Fines for holiday lights left up past January 6th. Fines issued retroactively for violations that had not technically been infractions until Karen decided, usually in a memo rather than a formal vote, that they were. The mechanism was fear. Not dramatic fear, not the kind that makes people flee. The slow, grinding, administrative kind. The kind where you start checking your own mailbox with a faint sense of dread. Where you mow the lawn on a Sunday just to make sure it doesn't hit 4 inches by Monday. Where you stop planting anything in your front yard because you're not sure what Karen will classify as non-compliant next season. Delia Marsh was the example that stayed with me longest. 74 years old, fixed income, widowed, lived 3 doors down from me in a house she and her late husband had owned for 19 years. The previous winter, a storm had blown her trash can from the side of the house into the street while she was in the hospital recovering from a hip replacement. She'd been admitted on a Tuesday. The trash can went into the street on a Thursday. Karen had a violation notice certified mailed to the hospital by Friday. The fine was $1,200, not for the trash can, technically, but for repeated failure to secure waste receptacles in compliance with community standards. It was Delia's first fine in 19 years of residency. She paid it. She told me later she'd been afraid that if she didn't, she'd lose the house. She wasn't entirely wrong to be afraid, that was the thing. The threat was engineered to feel just real enough to be believed. Karen's enforcement arm was her husband, Craig, a broad, quiet man who photographed violations from his car, delivered notices with the efficiency of someone who found the work genuinely satisfying, and attended every board meeting to stand slightly behind Karen, with his arms folded. The 2 remaining board members, I learned their names eventually, but in those early weeks I thought of them simply as the ones who vote yes, had been in their seats for 7 and 5 years respectively. Neither had run in a contested election. Neither, as far as anyone could tell, had ever voted against Karen on anything. I took all of this in over the course of 2 weeks. Quiet conversations in driveways, 1 cup of coffee on Fletcher's porch, a 10-minute exchange with Delia while I helped her carry groceries from her car. I didn't tell any of them what I did for a living. I was new. I was watching. And I had spent a long time in a profession where you learn that the most important thing you can do at the beginning of a situation is to say very little and remember everything. I started the log that second week. A simple, dated document on my laptop. Every interaction, every name, every amount, every date. The kind of record that feels excessive until the moment it doesn't. On a Tuesday evening toward the end of that first month, I mowed my lawn. Nothing unusual. Just a man mowing his lawn in the late afternoon. Across the street, Karen stood on her driveway with her clipboard and watched. I finished the front yard, turned off the mower, and gave her a neighborly wave. She wrote something on her clipboard. I went inside, and added a line to my log. The certified letter arrived on a Thursday morning, 10 days after Karen placed the violation notice under my windshield wiper. I signed for it at the door, brought it inside, set it on the kitchen table, and poured myself a second cup of coffee before I opened it. Not because I was nervous, because I wanted to read it carefully, and I find I read more carefully when I'm not rushing. The original $350 fine had become $500. The additional $150 was itemized as an administrative processing fee, which is a phrase that means nothing legally but sounds authoritative enough that most people just pay it. At the bottom of the letter, in bolded text, was the part Karen clearly considered her closing argument. Failure to remit payment within 30 days would result in the HOA filing a lien against the property at Lot 14B, Maplecrest subdivision. A lien, for anyone who hasn't had the pleasure, is a legal claim attached to your home's title. It doesn't mean you lose the house immediately. It means you can't sell it, can't refinance it, and carry a cloud over your ownership until the claim is resolved. HOAs use them the way some people use a thumb on a scale, not because the weight is legitimate, but because it changes the calculation. I read the letter twice. Then, I picked up my phone and called the county recorder's office. I identified myself, gave them the subdivision name and lot number, and asked one question: where does the recorded property line fall relative to the driveway apron at Lot 14B? The clerk put me on hold for 4 minutes. When she came back, she read me the boundary description from the 1987 subdivision plat. The driveway apron, the entire strip of concrete between my garage door and the public curb, fell within the recorded boundaries of Lot 14B. Not partially, entirely. By a margin of approximately 2 feet on the street side. I asked her to confirm. Was there any recorded easement on that lot granting the HOA access rights or common area designation over any portion of the property? She checked. No, sir. No easement of any kind recorded against Lot 14B. Not in 87, not since. I thanked her and requested a certified copy of the plat map. She said it would be ready for pickup in 2 business days. I told her I'd be there. So that was the thing about Karen's access strip claim, the strip that she'd described as HOA common area, the one she'd used to justify the fine, the one she'd cited on a pre-printed violation notice she'd apparently prepared before she even walked across the street. It didn't exist, not in any document, not in the plat, not in the deed, not in any easement filing at the county recorder's office. She had named a piece of my property as HOA common area and begun fining me for occupying it, and the entire legal foundation for that claim was, as far as the official record was concerned, nothing. She had invented it. I want to be precise about what I felt at that moment, because it wasn't anger. It was something closer to recognition. The feeling of looking at a situation and understanding exactly what it is. I sat down and wrote a response to the letter. 1 paragraph. No legal terminology, no heat. I cited the plat map by document number. Stated that the driveway apron fell entirely within my recorded property boundary. Disputed the fine as having no valid basis in the HOA's governing documents or county records, and requested that Karen provide the specific document she had referenced when she described the access strip as HOA common area. I asked her to respond within 15 business days. I sent it certified mail, return receipt requested, and kept a copy for the file. 3 days later, Craig appeared at my door. No Karen, just Craig. Alone, in the HOA polo shirt, with the particular expression of a man delivering a message he's been told is important. He told me the board had reviewed my letter and found it, in his exact words, non-responsive to the violation. The fine stood. If I wanted to dispute it, I was welcome to bring my concerns to the next board meeting. Though he wanted to warn me, and here he smiled slightly, the way people smile when they think they're being generous, that nobody wins arguments with this board. I asked him, calmly, if he could provide the document Karen had referenced regarding the access strip designation. He said that information was available to residents in good standing. I was not currently in good standing. I thanked him. I closed the door. I added Craig's visit to my log date, time, exact words, the smile. That afternoon I called a contact at the county assessor's office. I framed it as a professional inquiry, kept it neutral, asked whether there was any HOA easement or common area designation on record for Lot 14B, Maplecrest subdivision. My contact pulled it up and confirmed what the recorder's clerk had already told me. No easement. None ever recorded. He added, without much surprise in his voice, "Yeah, HOAs try that sometimes, especially the ones that have been running the same board for a while." I didn't explain why I was asking. I didn't need to. I laid everything out on the kitchen table that evening. The violation notice, Karen's signature, her handwriting, dated the day she placed it on my truck. The certified letter with the $500 demand and the lien threat. The plat map I'd picked up from the recorder's office that afternoon. The assessor's confirmation. Craig's visit, documented in the log. 4 items. 4 pieces of a foundation. I wasn't angry. I was building. And the thing about building a case is that you need the other side to keep adding to it. You need them to keep talking, keep threatening, keep generating paper. Every letter they send is a document. Every visit Craig makes is a witness event. Every phone call Karen logs with the 911 dispatcher is a record. Karen, bless her heart, was very cooperative. I want to be clear about something before I tell you what happened next. I did not go door to door in Maple Crest looking for allies. I did not organize a resistance movement, did not start a group chat, did not post anything on the neighborhood app. That is not how I operate, and frankly, it is not how you build anything that holds up later. What I did was simpler than that. I knocked on doors, introduced myself as the new resident on Halston Court, and said the same thing to everyone. I'm dealing with a situation with the board. I'd like to understand what others have experienced. Then I stopped talking and listened. It took 2 weeks, 11 conversations. And what I heard, laid end to end, was not a collection of isolated complaints. It was a system. Fletcher Odom was the first one to sit down with me properly. We were on his porch on a Saturday afternoon, 2 cups of coffee, and he talked for 40 minutes without me asking more than 3 questions. Fletcher had lived in Maple Crest for 6 years, ran a small landscaping crew out of his garage, and had the particular exhaustion of someone who has been fighting a low-grade battle for long enough that they've almost forgotten what it felt like before. He'd been fined for the color of his garage door, not the wrong color, technically, just a shade Karen had decided was inconsistent with community aesthetic standards, in a memo she'd written and circulated, without a board vote. He'd paid it. Then he'd been fined for the equipment trailer he parked in his own driveway twice a week for loading and unloading. He'd contested that one. That was when Karen had made the comment that Fletcher had been smart enough to record. He pulled out his phone and played it for me. Karen's voice, clear and unhurried, from a board meeting 8 months earlier. The board has full authority to assess daily fines for ongoing non-compliance, and we have pursued legal action before. We will do it again. The question is whether residents want to make this expensive for themselves or not. Nobody in that room had questioned her. Nobody had asked what legal action, or against whom, or under what authority. They had simply absorbed the threat and gone home. I asked Fletcher if I could have a copy of that recording. He sent it to me before I left the porch. Delia Marsh, I already knew from carrying her groceries. When I knocked on her door that second week, she invited me in for tea and told me the full story herself, unprompted, as though she'd been waiting for someone to ask. The storm, the hospital, the trash can, the certified mailed notice. She went to a drawer in her kitchen and came back with a folder she'd kept everything, every piece of paper the HOA had ever sent her, organized by date in a manila folder. She'd labeled HOA in her careful handwriting. 19 years of mostly nothing. And then, in the last 3 years, 4 notices and 2 fines, totaling $1,640. She'd paid both fines. The $1,200 Storm 1 and a $440 fine the previous summer for a garden ornament. Karen had deemed non-compliant with community aesthetic guidelines. A ceramic bird, 22 years old. Her late husband had bought it at a craft fair the year before he died. I asked if she'd be willing to write down what had happened, sign it, and let me keep a copy. She looked at me for a moment across the kitchen table. "Are you going to do something about this?" I told her I was working on it. She said that was good enough for her, and got out a pen. Over the following days, I spoke to 9 more residents. The pattern that emerged was not random. It was targeted, repetitive, and financial. Of the 11 people I spoke with, 9 had paid at least 1 fine they believed was unjustified. 6 had paid multiple. 3 told me they lived in active fear of their mailbox, not a metaphor, a literal daily anxiety about what might be in it. 2 had consulted attorneys about contesting fines and been told that fighting an HOA lien could cost more in legal fees than the fine itself, which is the exact calculation Karen was counting on. I went home and built a spreadsheet. names with permission, documented dates, fine amounts, descriptions of the alleged violations. I cross-referenced the amounts against the HOA's published annual financial reports, which by law had to be made available to all residents. The financial reports listed total fine revenue for each of the past 3 years. When I added up the disputed fines from my spreadsheet, the number I got was $47,000 that did not appear anywhere in the reported revenue line. $47,000 collected from residents, documented in their own records, absent from the HOA's official accounting. That was not a rounding error. That was not a clerical oversight. That was a number that was going to need an explanation. I spent one evening reading the state's HOA statutes. Not as a lawyer, I want to be clear about that. I am not a lawyer, and I was not practicing law. I was reading the way I have always read regulations. Carefully, with a highlighter, asking one question at a time. What I found was not complicated. Misappropriation of HOA funds. Potential state attorney general jurisdiction. Conducting board meetings without proper quorum. Violation of state statute. Serving beyond bylaw mandated term limits without a valid election. Also a violation, separately actionable. 3 categories. All documented. All sitting in my file. None of my neighbors knew what I did for a living. To everyone in Maplecrest, I was simply the new guy on Halston Court, quiet, methodical, showed up with coffee, and asked reasonable questions. Fletcher, at the end of our porch conversation, had looked at me sideways and said, "Are you a lawyer or something?" I said no. He said, "You think like one." I told him I'd just had a lot of practice reading documents. I went home that evening and set the file on my desk. It had grown in 2 weeks from a single folder with 4 items to a tabbed binder with 31 documents, a signed statement from Delia Marsh, a copy of Fletcher's recording, 4 additional written accounts from neighbors, and a spreadsheet with a number at the bottom that I kept coming back to. $47,000. I set the binder on my desk next to the only other object there that carried the same kind of weight. I didn't describe it then. I didn't need to. I already knew exactly what it was and exactly when I was going to use it. The lien arrived on day 31. I know it was day 31 because I had been counting, not obsessively the way you count, because you understand that deadlines matter and that the other side is also counting, and you want to know exactly where you are in the timeline at any given moment. The certified letter from the county recorder's office arrived in my mailbox on a Tuesday morning, and it confirmed that the Maplecrest HOA had filed a lien against Lot 14B for the amount of $650, the original $500 demand, plus an additional $150 in what the document called continuing assessment. FACE, which is a phrase invented specifically to make a number grow while you're not looking. I read the lien filing the way I read most documents Karen generated. Carefully, without expression, making a note of every detail that was going to matter later. The filing date, the notary stamp, the name of the HOA attorney who had signed at a firm I didn't recognize, which told me Karen had retained outside counsel at some point without informing the board, or had informed the board and gotten a yes vote in a meeting she hadn't properly noticed. Either way, another item for the file. I set it on the desk and went to make coffee. That same week, a new document appeared under every door in Maplecrest. Karen had typed it on HOA letterhead and titled it a board resolution regarding ongoing non-compliance at Lot 14B. The resolution stated that due to repeated violations and hazardous obstruction of community access, the board had voted to declare the driveway apron at my address a restricted access zone, pending resolution of the dispute. It cited the lien as evidence of my non-compliance. It announced that enforcement markers would be placed at the property boundary to preserve community access rights. The enforcement markers turned out to be wooden stakes with hand-lettered signs that said HOA restricted zone, no parking. Craig placed them at the end of my driveway. I know exactly when he placed them because 3 days earlier, after receiving the lien notice, I had installed a security camera above my garage door. Not a complicated setup, a standard weatherproof unit pointed down the driveway toward the street, motion activated, time stamped. I had ordered it the same afternoon I retained the attorney, which I will get to in a moment. The footage from that Thursday morning was unambiguous. Craig's car pulled up at 6:03 a.m. He got out carrying 2 orange traffic cones and 3 wooden stakes. He walked onto my driveway apron, not the curb, not the street, my driveway apron, well within the recorded property boundary, and spent 4 minutes placing the cones and driving the stakes into the ground at intervals. He took 2 photographs of his work. Then he got back in his car and left. I watched the footage twice. Then I saved it to 2 separate drives and emailed a copy to my attorney. The attorney I had retained 2 days after the lien arrived was not a friend, not a favor, and not cheap. I hired her because she had a specific practice area, HOA law and property rights disputes, and because when I called her office and described the situation in 3 sentences, she said send me the file before I finished the 3rd one. Her name was Joanna Reyes, and she had the particular quality I look for in professionals. She asked good questions and she listened to the answers. I sent her the binder. She called me back the following evening. Her assessment was efficient. The lien was improperly filed, the access strip claim was legally unsupported, and the board's resolution was unenforceable, given that the property boundary documents contradicted Karen's foundational premise. She recommended 3 simultaneous filings: a quiet title action to formally establish the driveway apron as exclusively my property in the court record, a petition to vacate the lien, and a complaint to the State Attorney General's HOA Enforcement Division regarding the financial discrepancy and the term limit violations. She also sent the HOA a formal preservation of evidence letter, all communications, all financial records, all meeting minutes, all board correspondence, retained and not destroyed, pending potential litigation. I told her to proceed. She asked if I wanted to move quickly. I told her I wanted to move correctly. She said those were the same thing in her experience. I said I was glad we were on the same page. 2 days after Craig's early morning cone installation, I was walking out to my truck when Karen appeared at the end of the driveway. She was holding her phone with both hands, already dialing, and she had the expression of someone who had been waiting for this moment and was pleased it had finally arrived. "I'm calling the police again," she said. "This is your final warning. Those cones stay where they are. If you move them or continue to obstruct this access zone, I will have you physically removed from this property. I want you to understand the geometry of that sentence." She was standing at the end of my driveway, on a strip of concrete that the county recorder's certified plat confirmed was my property, threatening to have me physically removed from it by the police department that I ran. I put my hands in my pockets. I waited. The dispatch call went out on the same channel it always did. I heard the familiar cadence through her phone speaker. This time, the responding unit was Officer Rains, 8 months on the force, my most recent hire before I'd taken a short leave to handle the move and the divorce paperwork. Good instincts, careful with procedure, still learning when to talk and when to be quiet. He pulled up 4 minutes later, stepped out of the car, and looked at the scene. Karen, at the end of the driveway, cones on the apron, me standing next to my truck with my hands in my pockets. His eyes moved from Karen to me. There was a pause. A very specific pause, the kind that happens when someone's brain is reconciling 2 things that shouldn't be in the same location at the same time. "Good morning, sir," he said. His voice was careful in a way that Karen didn't have the context to understand. Karen stepped forward immediately. "Officer, this man has been repeatedly warned about blocking HOA common property. He's in violation of a board resolution. I need him removed." Rains looked at the cones on the driveway, looked at me. I gave him the smallest shake of my head. "Not now." He processed that in about half a second and turned back to Karen with the measured tone of someone buying time professionally. "Ma'am, before I can take any action, I'm going to need to review the property documentation. This looks like a boundary dispute, and I can't enforce a removal without verifying the legal status of the property." He offered her his card. He told her he'd be in touch. He was back in his car in 90 seconds. Karen watched the squad car pull away, and then turned to me with the satisfied expression of someone who believes they've just won something. "See," she said, "even the police know you're wrong." I looked at her for a moment. I thought about explaining what had just actually happened in that exchange, what Rains's careful tone meant, what I need to review the property documentation meant, what the specific way he'd said "Good morning, sir" meant if you knew what you were listening for. I decided against it. "Have a good morning, Karen," I said, and got in my truck. Karen had now filed a lien against a police chief's home, placed illegal obstructions on his property twice using the police department he commanded as her enforcement tool, and generated enough documented bad faith to keep an attorney busy for 6 months. The only question was how long I was going to let her keep building the case against herself. The answer, I had decided that morning, was not much longer. The notice appeared under every door in Maple Crest on a Wednesday evening. Karen had called an emergency board meeting for the following Monday. The stated purpose, typed on HOA letterhead in the same font she used for violation notices, was to formalize the access strip resolution and authorize legal action to enforce community property rights at Lot 14B. There was a line at the bottom reminding residents that attendance was encouraged but not required, which was Karen's way of saying she expected the folding chairs to be empty, the way they always were, so she could conduct her business without an audience. I read the notice twice. Then I called Joanna. "They're going to push for an injunction," I said. There was a brief pause on her end, then, "Let them file it. I want them to file it." I understood immediately. An injunction application meant a hearing. A hearing meant a judge, a courtroom, sworn testimony, and the full evidentiary record laid out in front of someone with actual jurisdiction. Karen had spent 9 years operating in the vacuum of an HOA clubhouse, where she was simultaneously the prosecutor, the judge, and the only one who knew the rules. A courtroom was a different environment entirely. I told Joanna to be ready to move fast once the filing came through. The next 2 days I spent quietly. I put together a 1-page document, no name on it, no letterhead, nothing that looked like a legal filing or an organizing document, just facts, dates, fine amounts, the bylaw section number for term limits, the $47,000 figure with a note explaining where it came from, and a single question at the bottom: "Did you pay a fine that appears on this list? Keep your receipts." I printed 12 copies and slipped one under the door of every neighbor I'd spoken with over the past 2 weeks. I did it on a Friday evening, unhurried, the way you do something when you're confident in the outcome. Monday came. The HOA clubhouse was a low-ceilinged room with fluorescent lighting, stackable chairs, and a folding table at the front where Karen and her board sat. I had been in thousands of rooms like it over the years, the kind of room where people make decisions that affect other people's lives, decorated with the minimum required to suggest legitimacy. A podium, a gavel, a laminated copy of the HOA rules on the wall. 12 residents were there when I walked in. 12. Karen had held board meetings for years with 2 attendees, sometimes 3. She looked at the chairs, filling up with an expression that moved quickly from surprise to something more controlled and professional, the way people look when they realize the game has changed, but haven't decided how to respond yet. Karen opened the meeting by reading the lien against Lot 14B into the formal record. She described the history of the dispute in the careful language of someone who has prepared remarks. A new resident, repeated non-compliance, community standards undermined, the board's reluctant but necessary decision to pursue legal remedies. She announced that the board was prepared to seek injunctive relief in civil court to permanently restrict access to the disputed property boundary and enforce the HOA's community rights. She was good at it. I'll give her that. If you didn't know what you were listening to, it sounded reasonable. When the chair opened the floor for resident comment, I stood up. I had 3 minutes by the meeting rules. I used 2 of them. I stated, at normal volume, without notes, that the access strip Karen had cited in every violation notice, every demand letter, and every board resolution did not exist in any recorded document at the county recorder's office or the county assessor's office. I cited the plat map by document number. I cited the assessor's confirmation by date. I stated that the lien filed against Lot 14B was therefore based on a premise that had no legal foundation. I stated that the HOA's published financial reports for the past 3 fiscal years showed a $47,000 discrepancy relative to the fine amounts documented in residents' own records, and that I intended to forward that documentation to the State Attorney General's HOA Enforcement Division. I stated that Section 4.3 of the HOA's own bylaws limited board members to 2 consecutive terms, that Karen was currently serving her 4th, and that this represented a violation of the governing documents the board claimed authority to enforce. Then I sat down. The room was quiet for a moment in the way rooms get quiet when something has shifted and people are still processing what direction it shifted in. Karen said, "Your objections are noted and rejected. We'll proceed to the vote." Before she could call it, Delia Marsh stood up. 74 years old, 5 feet 2, with the folder she'd shown me at her kitchen table tucked under her arm. She said she had been fined $1,200 during a hospital stay for a weather event she could not have controlled, and she would like to know under what specific bylaw provision that fine had been assessed. Karen said the board had addressed that matter, and it was closed. Delia said she did not believe it had been addressed, and she remained standing. Fletcher stood up next. He said he had been fined for a garage door color that was not listed as prohibited in any version of the community guidelines he had been provided, and he would also like a specific citation. then two others, then a third, each one standing, each one with a specific fine and a specific question, each one using the same careful, factual language that I recognized because I had spent 2 weeks having coffee with all of them. Karen called the vote. 3-0, as expected. The board authorized pursuit of injunctive relief. The meeting adjourned. In the parking lot afterward, 5 residents stopped me near my truck. They didn't ask what I did for a living. They asked what was going to happen next. I told them to write down everything they remembered, dates, amounts, what was said, what was threatened, sign it, and keep a copy. I told them to hang on to every piece of paper the HOA had ever sent them. Delia touched my arm before she left. What are you going to do? I thought about how to answer that in a way that was accurate and also complete. I'm going to let her explain herself, I said, in front of people who actually have jurisdiction. Delia nodded once, the way people nod when they've been waiting a long time to hear something and it finally sounds right. I drove home and called Joanna. They voted for the injunction. Good, she said. Karen had just voted herself into a courtroom. She didn't know that the person filing the response to her injunction would be recognized by the judge before he reached the podium, because he had testified in that same courtroom 46 times. The injunction hearing was scheduled for a Thursday morning, 3 weeks after the board meeting. Karen arrived with her HOA attorney, a junior associate from a mid-sized firm downtown, carrying a leather portfolio and the particular expression of someone who had reviewed the file the previous evening and was quietly hoping the other side wouldn't show up with anything complicated. Karen was in a blazer over her HOA polo, which I noted because it suggested she understood this was a different kind of room than the clubhouse. She was right about that. She was wrong about almost everything else. I arrived with Joanna Reyes, a binder organized into 9 tabbed sections, and 31 years of knowing exactly how courtrooms work. The courtroom itself was unremarkable civil division, county courthouse, wood paneling that had been there since the 80s, fluorescent lights that hummed at a frequency designed to make everyone slightly uncomfortable. I had testified in this room 46 times. I knew which chair creaked, which microphone cut out if you spoke too quietly, and the name of the clerk who had been there longer than any of the judges. I did not mention any of this. I sat down, set the binder on the table, and waited. Judge Patricia Okafor presided. Efficient, precise, with the particular patience of someone who has heard every variation of every argument and has learned to identify the ones that matter in the first 2 minutes. She called the case, confirmed the parties, and asked the HOA's attorney to present the basis for the injunction. He spoke for 8 minutes. The access strip, the community property rights, the ongoing non-compliance, the lien, the board resolution. He cited no specific document numbers. He referenced the HOA's governing authority in general terms. When he finished, Judge Okafor looked at Joanna and said, "Response?" Joanna stood. "Your Honor, before the court entertains the HOA's motion, we'd like to present foundational evidence that directly contradicts the premise of the injunction. With your permission, 5 minutes." The judge nodded. "Proceed." Joanna set the first document on the table and handed a copy to the clerk. The 1987 subdivision plat, county recorder's certified copy, document number stamped in the corner. She walked the judge through the boundary description for Lot 14B, the property line, the driveway apron, the precise measurement placing the outer edge of the apron 2 feet inside the recorded boundary. The access strip that Karen had cited in every violation notice, every demand letter, and the injunction application itself. The strip she had described as recorded HOA common area fell entirely within my private property. Not partially, not ambiguously, entirely. "Is there a recorded easement granting the HOA any rights over this strip?" Joanna asked, directing the question to the room rather than to anyone in particular. She set the second document on the table. County assessor's written confirmation, dated and signed. No easement of any kind had ever been recorded against Lot 14B, not in 1987, when the subdivision was platted, not in the 38 years since. Karen's attorney leaned over and said something to her in a low voice. She shook her head. "Your Honor," Joanna continued, "the entire legal foundation of this injunction is a property designation that does not exist in any recorded document. The access strip is not HOA common area. It has never been HOA common area. The HOA president either did not verify this before initiating enforcement action, or verified it and proceeded regardless. Either way, the injunction has no legal basis." Judge Okafor made a note. Continue. The financial discrepancy. Joanna set the spreadsheet on the table, 2 columns, 12 pages, organized by year. Fines documented in residents' own records on the left, amounts appearing in the HOA's published financial reports on the right. The gap between the 2 columns, totaled at the bottom of page 12, was $47,000. We are not asking this court to adjudicate the disposition of these funds today, Joanna said. We are entering this documentation into the record and stating for the transcript that we will be forwarding a complete copy to the State Attorney General's HOA Enforcement Division, along with documentation of the board president's service beyond the term limits specified in the HOA's own governing documents, now in her 4th consecutive term, against a bylaw cap of 2. One of Karen's board members, seated in the gallery behind her, stopped writing in his notepad. The other one was looking at the exit. Joanna set the 3rd document on the table. A tablet, screen up, connected to the courtroom's display monitor. Fletcher's recording. Karen's voice, 8 months ago, in the clubhouse with the fluorescent lights humming. The board has full authority to assess daily fines for ongoing non-compliance, and we have pursued legal action before. We will do it again. The question is whether residents want to make this expensive for themselves or not. The HOA attorney set down his pen. The security camera footage next. Craig's car, 6:03 a.m., time-stamped in the corner of the frame. Craig, carrying orange cones and wooden stakes onto the driveway apron. The same apron the plat map showed as exclusively my property. Craig driving the stakes into the ground. Craig photographing his work. The whole sequence, 2 minutes and 40 seconds. Silent except for the courtroom's ambient hum. Judge Okafor watched the footage without expression. When it ended, she said, "This was before any court order authorized access restriction?" "Correct, Your Honor." The HOA board passed an internal resolution, but no court had ordered or sanctioned the placement of these markers on private property. Delia Marsh's sworn statement was read into the record by Joanna. Fined $1,200 during a hospital stay. 19 years of clean compliance. The certified mail notice sent to the hospital while she was recovering from surgery. Then the 4 additional resident affidavits, Fletcher's, and 3 others, each documenting a fine with no specific bylaw citation, each signed and dated. Karen's attorney requested a recess. Judge Okafor looked at him with the particular patience of someone who has heard that request at this specific moment in a hearing many times before. Denied. Will continue. The lien filing itself was entered last. Joanna noted for the record that it had been filed on day 31 of a 30-day payment window, that the underlying fine was based on the non-existent access strip designation, and that the filing therefore constituted an encumbrance placed on private property without valid legal basis relevant, she said, to the question of bad faith. The HOA attorney was no longer writing anything down. Judge Okafor ruled from the bench. She did not take time to deliberate. She had everything she needed. Injunction, denied. Lien against lot, 14B, vacated, effective immediately. HOA ordered to refrain from any further enforcement action on the property, pending a full judicial review of the board's governing authority and financial records. The court would retain jurisdiction. She looked up from her notes, and her eyes settled on me directly, with the particular recognition of someone placing a face in the right context. "Chief." She said it simply, the way you acknowledge a colleague. "I didn't recognize you out of uniform." The word landed in the room the way a single stone lands in still water quietly, and then in every direction at once. Karen's head turned. Her attorney turned. The 2 board members in the gallery went very still. I said, "I've been meaning to get back to work, Your Honor." The judge looked down at her notes. Something moved at the corner of her mouth that she chose not to let become anything. "I imagine you have." Karen said nothing. There was nothing to say. The room she had voted herself into had just introduced itself, and it was not the room she had been running for 9 years. Court adjourned. Word travels in a neighborhood the way water travels on a flat surface, without direction, without announcement, finding every low point on its own. I did not tell anyone what had happened in that courtroom. I did not call Fletcher from the parking lot or knock on Delia's door on my way home. I drove back to Halston Court, changed out of the clothes I'd worn to the hearing, and went to the grocery store because I was out of coffee and eggs. That was Thursday. By Friday evening, every resident in Maplecrest knew that Karen Whitfield had taken a police chief to civil court over his own driveway and lost in the same session the judge had used to address her by his title. The word chief had done the rest on its own. I went back to work the following Monday. Not dramatically, not with any particular sense of ceremony. I drove to the precinct, sat down at my desk, reviewed the weekend reports, had a conversation with my deputy about a staffing issue we'd been putting off, and ate lunch at my desk, the same way I had eaten lunch at my desk for the better part of 3 decades. The divorce had taken me out of my normal rhythm for the better part of a year. The move, the unpacking, Karen's escalating campaign of certified letters and orange traffic cones, all of it had been noise running underneath a life I was trying to rebuild. Monday felt like the noise had finally stopped. Officer Raines stopped by my office that afternoon. He stood in the doorway for a moment with the expression of someone who has a question he's been holding for a while, and has finally decided to ask it. I told him to come in and sit down. He said he'd been in the car the second time Karen called 911. He said he'd recognized me right away, but wasn't sure what the right move was. And he'd made the call to stall rather than engage without knowing what I wanted. I told him that was exactly the right call. He nodded. Then he said, "She really didn't know, did she?" I said no, she really didn't. He thought about that for a moment and then went back to his desk, and neither of us brought it up again. The legal proceedings moved on their own momentum after the hearing, the way properly filed paperwork tends to do when it's been organized by someone who knows what they're doing. Joanna filed the formal complaint with the State Attorney General's HOA Enforcement Division 10 days after the hearing. The financial discrepancy, documentation, the term limit violations, the meeting records, all of it packaged and submitted with a cover letter that ran 4 pages. The AG's office acknowledged receipt within the week and opened a formal inquiry. That process would take months and was not mine to manage. I had handed it to the people with the jurisdiction to manage it and returned to my own work. The civil suit came from 3 directions at once, which I had not orchestrated and could not have if I'd tried. Fletcher filed first, for harassment and coercion, citing the recording and the pattern of retaliatory fines. 2 other residents joined within a week. Karen and Craig were named personally. Their HOA attorney, to his credit, advised them to settle rather than litigate, and they did, quietly, for an amount that was not made public, but that Fletcher described to me later as enough to feel like something. I did not ask for a number. It wasn't my business. Delia Marsh's restitution check arrived on a Tuesday afternoon, issued by the interim HOA treasurer, one of the new residents who had stepped in to manage the board's finances while the formal election was organized. The check was for $1,640, covering both fines she had paid under protest. She called me when it arrived. I could hear something in her voice that she was trying to hold steady and not quite managing. She said she was going to use the money to fix her gutters, which had been sagging since the previous fall. I told her that sounded exactly right. The election happened 3 weeks later. 89 of 96 households voted. The previous high, in the 9 years Karen had been running the board, was 22. The new board had 4 members: a retired teacher, a contractor, a young woman who had moved in the previous spring and immediately become the most organized person at any meeting she attended, and Delia Marsh, who was elected treasurer by the widest margin of anyone on the ballot. Their first official act as a board was to suspend all pending fines under active review and commission, an independent financial audit of the HOA's accounts for the previous 5 years. Karen resigned from the board the day the election results were certified. She did not send a letter to the community. She did not appear at the new board's first meeting. Craig stopped appearing at neighborhood events. The 2 former board members declined to run in the election, and had not, as far as I knew, attended any community function since the hearing. The HOA polo shirts disappeared from the neighborhood the way bad weather disappears gradually, and then completely, and then you realize you haven't thought about them in weeks. I finished the shelf in my garage on a Saturday afternoon in late November. It had taken longer than it should have. I kept getting called back to the precinct, kept finding other things to do on weekends. The way you find other things to do when you're not quite ready to admit that a project you started in anger has become something you're finishing in peace. I put the last bracket in, stepped back, tested the weight, and decided it was good. Delia knocked on the open garage door about 20 minutes later with a plate of something that turned out to be a kind of almond cake her late husband had liked. She came in and looked around the garage with the particular approval of someone who believes in the value of a well-organized space. We talked for a while about nothing consequential, the new board's first meeting, the gutters she'd had fixed, a bird she'd seen in her backyard that she couldn't identify. Easy conversation, the kind that happens between people who have been through something together and don't need to talk about it directly anymore. Before she left, she stopped and looked at the framed document I had hung on the garage wall the week before. The certified copy of the 1987 subdivision plat, Lot 14B, the boundary line drawn in ink that had outlasted everyone who had ever tried to argue with it. County recorder's stamp in the corner, document number along the bottom edge. "Is that the paper that fixed everything?" she asked. I thought about how to answer that accurately. "That's the paper that was always true," I said. "We just had to make the record match it." She looked at it for another moment, nodded once, and took her plate home. I went back to the shelf, ran my hand along the edge of the wood, checked the level one more time out of habit. Everything straight. Everything where it was supposed to be. I never did put up a gate. I thought about it briefly, sometime around the third certified letter, when Craig was photographing my driveway from his car. But a gate would have been a concession to the idea that my property needed defending. And my property didn't need defending. It needed the record to accurately reflect what had always been true about it. That was all. The driveway apron had been mine since the ink dried on a county deed in 1987. It was mine, on the morning Karen placed that violation notice under my wiper. It was mine in the courtroom, when the judge said my name. It was mine on the Saturday afternoon. I stood in my garage and listened to a mockingbird in the yard next door, and heard, for the first time since I moved to Maple Crest, nothing else at all. The calm the listing had promised. It turned out to be accurate. It just took a little longer to arrive than advertised.